that protection. The gentleman knows I hold, no, I will not. The gentleman knows, the gentleman knows,
I didn't hear from the gentleman.
The gentleman knows that I have great affection for him. But I must say he is becoming exceedingly hard to please. I yield back.
The gentleman yields back. Members are reminded not to traffic the well while another member is under recognition. Without objection, the previous question is ordered. The question is on the motion to recommit. Those in favor will say aye. Those opposed will say no. The noes have it.
Vote.
The gentleman from California.
Request
for recorded vote. A recorded vote is requested. Those favoring a recorded vote will rise. A sufficient number having risen, a recorded vote is ordered. Members will record their votes by electronic device. Pursuant to Clause 9 of Rule 20, the Chair will reduce to 5 minutes the minimum time for any electronic vote on the question of passage.
H.R. 1837 would affect California's state water and environmental regulations in the San Joaquin Valley. This is a motion to recommit offered by Democrat John Garamendi, which would add a savings clause that prohibits the underlying bill from preempting or superseding state law, including state water law, effectively killing the bill. This is a 15-minute vote on the motion to recommit. Final passage vote is next. Over in the Senate today, plenty of speeches about the transportation bill, and also in particular about an amendment to that bill that's been offered by Missouri Republican Roy Blunt. His amendment would allow health insurance plans to decline to cover an item if it's against the issuer's religious beliefs. A vote in relation to the amendment is set for Thursday. During this vote, we're going to show you Senator Blunt on the Senate floor earlier today talking about his amendment.
I want to talk about an amendment that's had lots of attention. It's an amendment that I offered on the floor a couple of weeks ago, and we weren't able, the leader didn't want to get to it at the time, but the majority leader brought it up for me yesterday, and I'm glad he did. I'm glad we're able to talk about it. This is an amendment that would allow religious belief or moral conviction to be an important factor in whether or not people comply with new health care mandates. Now, we have long, Mr. President, had this exemption for hiring mandates, and in fact, when I served in the House of Representatives, I'd been the president of a Southern Baptist university. I understood the importance of these institutions. I thought maintaining their faith distinctives as part of why they provide education and health care and daycare and other things. And so I have long been an advocate of a principle that the Supreme Court held up just a few weeks ago, 9-0, that there is a difference in these faith-based institutions. And now that we have health care mandates that could apply to these institutions, all this amendment does is extend the same privilege to them and others who have a religious belief or moral conviction that would they'd be able to defend their moral conviction. We don't do anything about the mandate itself. It's important to understand, Mr. President, that the administration, this one or any other, if the Affordable Health Care Act is still in force, can issue all the mandates that the Act would allow. And in fact, if you don't comply with those mandates, you'd have the penalties that the Act would allow. But the difference is if the government wouldn't recognize your religious belief or moral conviction, as I think they would likely do. For example, the Archdiocese of Washington, D.C. saying this is something we have long held as a tenet of our faith that we don't believe should happen and we shouldn't be part of, and we don't want it to be part of the insurance policies of our schools or our hospitals. My guess is if we pass this amendment, without any question, the Justice Department would say, well, you're certainly going to be able to defend that because that's been your belief for centuries in your faith. This amendment doesn't mention any procedure of any kind. In fact, just this morning we had a reporter call the office and said, we can't find the word contraception in this amendment anywhere. How's this a vote on contraception? Of course, we were able to say, as we had said 4 days, the word contraception is not in there because it's not about a specific procedure. It's about a faith principle that the First Amendment guarantees. And, Mr. President, this language, this exact language of religious belief or moral conviction was first used in 1973 in the Public Health Services Act, brought to the Senate floor by Senator Church from Idaho, who I believe was considered one of the liberals of the Senate at the time, protecting health care providers from having to be involved in procedures they didn't agree with. It's part of the Legal Services Corporation limitation in 1974, the foreign aid funding limitation in 1986, the refusal to participate in executions or prosecutions of capital crimes in 1994, the vaccination bill that if you come to this country as a non-resident and you don't want to have vaccinations that are otherwise required, you don't have to have them if you have a religious belief or moral conviction against them. And the list, Mr. President, goes on and on. The Medicare and Medicaid Counseling Act, the Federal Employees Health Benefits Plan of 1998, the contraception coverage for federal employees in 1999, the D.C. contraception mandate in 2000, the United States Leadership Against AIDS Act in 2003. And then, Mr. President, it's this exact same language, even more specifically, has been in bills that weren't passed. In 1994, Senator Moynihan from New York brought a bill to the floor that Mrs. Clinton, later Senator Clinton, now Secretary Clinton, was very involved in, this 1994 health discussion. And that bill said nothing in this title should be construed to prevent any employer from contributing to the purchase of a standard benefits package which excludes coverage for abortion or other services if the employer objects to such services on the basis of religious belief or moral conviction. This is Senator Moynihan less than 20 years ago in what was considered a liberal piece of legislation, putting what the country had thought since the beginning of government-paid health care was just a natural part of every health care bill. In fact, the bill we're talking about that this amendment would impact is the first time that the federal government has passed a health care bill that didn't include this language. The first time it didn't include this language. And, you know, if you're not offended by the current mandate that some religions are, I think it's important to think of what you would be offended by. What in your faith would be an offensive thing to be told you had to be part of, and then imagine the government saying, no, you have to be part of that. And even if you don't do it yourself, you have to pay for it. Or you have to be sure that your employees, your associates are part of this thing that is offensive to you because of religious belief or moral conviction. Now, before I go to my good friend Senator Johans, who understands this issue so well, let me also say that, as I said, Mr. President, we didn't eliminate the mandate, so you can still have the mandate. The federal government can still come in and say, you're not offering these services, so you have to pay the penalty, and then you have to be able to go to court and prove that you have a long-held belief that this is wrong. You know, the court in 1965, when this particular phrase became the boilerplate phrase for the law, the court said you can't become a conscientious objector the day you get your draft notice, in essence. That you have to have these two principles. You have to have religious belief, strong moral conviction, and you have to be able to go to court and prove that. All of the fiction writers out there in fundraising letters and otherwise saying things like women who have contraceptive services today wouldn't have them, of course that's not true. Of course that's not true. The women that have those services today either have them because they've found a way to pay for them themselves or they have an employer who's providing that as part of health care. that employer is not going to be able to turn around and say, I'm not for that anymore because I object for some religious reason that I didn't have all the time I was providing it. This is an important issue. It is a First Amendment issue. It's an issue that group after group after group think it violates the Religious Freedom Act, RFRA. There are 6 lawsuits already. I suspect that they have a good chance of prevailing because it does exactly what the religious freedom law says you can't do. It needlessly forces people to participate in activities that are against their moral principles, their religious principles. The circumstance in the country we have 220 years of history of this. We have almost 50 years of history of government-paid health care for one group or another that always included an exemption like this exemption. To not do this assumes that the government can make people do things that Thomas Jefferson and George Washington and others specifically said were among the rights that we should defend the most vigorously, that we should hold the most dear, that we should not let a government interfere in these basic rights of conscience, a term of Thomas Jefferson when he wrote the New London Methodist in 1809. These rights of conscience are an area that we should not let the government get between the American people and their religious beliefs. And our laws since then, whether it's for hiring or in the case of any health care discussion, have always anticipated the protection of this First Amendment right. Not a specific thing, but again, if you're not offended by the things that some people are concerned about today, it's important to think of what you would be offended by. What your religious belief leads you to believe would be wrong, and how you would feel if the government says, now you have to be a part of that activity. And I'd like to turn to my good friend from Nebraska, who has been a real advocate of understanding the importance of the First Amendment and the role it plays in our society.
Senator Roy Blunt from earlier today on the floor of the U.S. Senate. Again, a vote on his amendment related to his amendment tomorrow on the Senate floor. Follow the debate on C-SPAN 2. Later in our program schedule, among the items we've covered today, several hearings on the proposed 2013 budget. We also covered a hearing today. The House Transportation Committee held a hearing looking at cruise ship safety. We'll show that to you later in our schedule. President Obama and the First Lady are hosting a dinner tonight for members of the military who served in Iraq and Afghanistan and their families, and we will bring you toast, live coverage of that at 8:20 Eastern or thereabouts, and that'll be on C-SPAN 2.
this vote, the ayes are 178 and the nays are 248. The motion is not adopted. The question is on passage of the bill. Those in favor will say aye. Those opposed will say no. The ayes have it.
Mr. Speaker,
Gentleman from California.
I request a recorded vote.
A recorded vote is requested. Those favoring a recorded vote will rise. A sufficient number having arisen, a recorded vote is ordered. Members will record their votes by electronic device. This will be a 5-minute vote.
And it's the final passage vote on a bill that would affect state environmental and water laws in California dealing with the San Joaquin Valley. 5-minute vote on the House floor. We expect them to take up a number of other bills before gaveling out this evening. They're back tomorrow morning at 9 o'clock Eastern to take up a resolution that directs the Office of the Historian to compile oral histories of House members who took part in the Civil Rights Movement, including the Selma to Montgomery marches. That's tomorrow, beginning at 9 o'clock, and live coverage, of course, here on C-SPAN.
this vote, the yeas are 246, the nays are 175, with one answering present. The bill is passed. Without objection, a motion to reconsider is laid on the table. For what purpose does the gentleman from Rhode Island seek recognition?
Mr. Speaker, I ask unanimous consent that Congressman Ed Royce be removed as a co-sponsor of H.R. 1912.
Without objection. For what purpose does the gentleman from Alabama seek recognition? Without objection.
Mr. Speaker, it is with a heavy heart that I bring to the attention of the House the news that a United States Coast Guard helicopter crashed last night in Mobile Bay during a training mission. Early this morning, I spoke by phone to Coast Guard Sector Commander Captain Don Rose in Mobile, where he informed me that one crew member had lost his life and 3 others are missing. Search efforts for the missing crew have been underway through last night and today, and they are ongoing at this time near the crash site off Point Clear, Alabama. Naturally, I offered to Captain Rose the prayers and heartfelt sympathies of the Congress, as well as our entire nation, not only to those immediate families of those brave coasties, but to the entire Coast Guard family. Whether during a hurricane, an oil spill, or one of their daily encounters with danger when conducting a search and rescue mission, the United States Coast Guard plays a vital role that we too often take for granted. It is at times like this when we are reminded of the dangers they face in their service to our nation. They are truly on the first line of protecting our country, and we can never thank them enough. Mr. Speaker, I ask at this time that all Americans lift a prayer to the good Lord for the loss of life that has occurred. May God's blessings and healing hand be on those left behind. I yield back.
For what purpose does the gentleman from Illinois wish to be recognized? Without objection.
Thank you, Mr. Speaker. I too come to the well to address a tragedy that happened this morning, early this morning. An F4 tornado hit the city of Harrisburg, Illinois, in my district. There is extensive damage and 6 residents lost their lives. Our thoughts and prayers are with those who lost family and friends, those who were injured, and those who lost their homes. I plan to visit Harrisburg personally tomorrow and thank all those first responders who have been working tirelessly to care for the injured and to begin the long road back to cleanup. The mutual aid provided by the surrounding communities is also very heartwarming. I pledge to work with Mayor Eric Gregg and other local officials to rebuild the Harrisburg we all know and love. Thank you, Mr. Speaker, and I yield back my time.
Pursuant to Clause 8 of Rule 20, the Chair will postpone further proceedings today on motions to suspend the rules on which a recorded vote or the yeas and nays are ordered, or on which the vote incurs objection under Clause 6 of Rule 20. Record votes on postponed questions will be taken later. For what purpose does the gentleman from Wisconsin seek recognition?
Mr. Speaker, I move to suspend the rules and pass the bill S. 1134 to authorize the St. Croix River Crossing Project with appropriate mitigation measures to promote river values.
The clerk will report the title of the bill.
Senate 1134, an act to authorize the St. Croix River Crossing Project with appropriate mitigation measures to promote river values.
Pursuant to the rule, the gentleman from Wisconsin, Mr. Petri, and the gentlewoman from Minnesota, Mrs. McCollum, each will control 20 minutes. The Chair recognizes the gentleman from Wisconsin.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks, include extraneous materials on the bill before us, S. 1134.
Without objection, so ordered.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
Passage of this bill, which was adopted by the Senate earlier this year by unanimous consent, will remove the last remaining roadblock to construction of a new bridge over the St. Croix River, a bridge that has been identified for replacement by the states of Wisconsin and Minnesota for nearly 60 years, and a project that has actively been worked on for more than 30 years. Support for this new bridge is bipartisan and bicameral. The governors of Wisconsin and Minnesota support it. The entire Senate delegations from the two states support it. With few exceptions, the members of the House delegations from Minnesota and Wisconsin support it. We just need this final action in order to finally proceed with the bridge. The longer we delay, the more unsafe the current lift bridge becomes, congestion continues to worsen, and costs just continue to rise. It's time to end the gridlock. I urge passage of the bill, and I reserve the balance of my time.
Gentleman reserves. The gentlelady from Minnesota is recognized.
Mr. Speaker, I claim as much time as I may consume. Mr. Speaker, the bill before the House today, S. 1134, is a controversial bill that represents wasteful government spending, bad transportation policy, and bad environmental policy. A new bridge across the protected St. Croix River between my state of Minnesota and Wisconsin needs to be built. The aging Stillwater lift bridge needs to be replaced, and everyone agrees on that. But I support a more affordable and more appropriately scaled replacement bridge. This bill is controversial because it does much more than authorize a replacement bridge. This bill mandates construction of an exotic and massive Extradose-style bridge some 219 feet above the St. Croix River at a cost of $700 million for only 18,000 cars per day. This $700 million Extradose, Mr. Speaker, the House is not in order.
Order.
This $700 million Extradose mega bridge will connect Oak Park Heights, Minnesota, population 4,700, and Holton, Wisconsin, population 386. I quote from the St. Paul Pioneer Press, January 25, 2012, about Holton, Wisconsin, quote, "It is not big enough for a stop sign on its main street." Holton, Wisconsin may not have a stop sign, but Congress could give it a $700 million bridge. This bill is controversial because if you look at page 2, line 10 of the bill, you will see that the bill dictates the location of this $700 million mega bridge. And I quote from the bill, approximately 6 miles north of Interstate 94 crossing. In other words, this bill mandates a 65-mile-per-hour interstate freeway bridge connecting a town of 368 people and builds it only 6 miles from an existing interstate crossing on the same river. What would the Tea Party call an effective, efficient use of taxpayers' dollars? Would they call this that? The fiscal watchdog group, Taxpayers for Common Sense, calls the bill, and I quote from them, a massive, intrusive misuse of taxpayer money. In a letter to Congress opposing this bill, the Taxpayers for Common Sense said, and I quote from them, in an era of trillion-dollar deficits and $15 trillion national debt, it is simply unacceptable to spend $700 million on a bridge to carry so few vehicles when an interstate bridge exists nearby. This bill is controversial because it is opposed by the Interior Department, which testified before the Senate Energy and National Resources Committee on July 28, 2011, opposing S. 1134. And I quote from the Director of the National Park Service when he stated, the Department cannot support this legislation as the National Park Service is determined that the St. Croix River project would have a direct and adverse impact to the river, and these impacts cannot be mitigated. To be very clear, I asked Interior Secretary Salazar 2 weeks ago during an Interior Appropriations Subcommittee a direct question, and that was on February 16th, just this month. I asked, does the Interior Department still oppose S. 1134? Interior Salazar responded saying, quote, our position remains unchanged. A wild and scenic river is a wild and scenic river. The position of the Park Service was articulated a year ago as the position of the Department. We have, as you know, Congresswoman McCollum, met with the delegations from the two states, Secretary LaHood and I have offered to work with a group to see whether or not an alternative can be found. End of quote from Secretary Salazar. Unfortunately, despite opposition from the Interior Department and an offer to work on a compromise solution, Congress will now be voting on a $700 million mega bridge. This bill is controversial because it will directly result in a property tax increase for the residents of Oak Park Heights, Minnesota, a community in which Minnesota's new redistricting map places it in my new congressional district. According to a unanimously passed resolution by the Oak Park Heights City Council, the passage of S. 1134 by Congress will do this to the City of Oak Park Heights. And I quote from the City Council's resolution. Quote, it will require an estimated $443 in annual property tax increases for the next 10 years to most city homeowners and business owners. A vote for S. 1134 will be a tax increase on Minnesotans. This bill is controversial because it puts Congress in the position of prioritizing spending of $700 million of taxpayers' money to replace one bridge, while Minnesota has more than 1,100 additionally structurally deficient bridges, far less costly, that all are in desperate need of repair or replacement. In fact, dozens of Minnesota state legislators wrote our delegation saying, and I quote, "We are united in our concerns that the current design of the bridge is far too expensive, particularly in light of much more cost-effective alternatives." Those state legislators, many from my congressional district, urged defeat of this legislation. Former Vice President and U.S. Senator Walter Mondale, an original sponsor of the Wild and Scenic River Act, opposes this bill, saying that the passage, and I quote from Vice President Mondale, would be a profound mistake, and he urges a vote against the bill. This bill was even controversial in the Senate. Senator Jeff Bingham, the chairman of the Senate Committee on Energy and National Resources, Senator Mark Udall of Colorado, Senator Marie Cantwell of Washington opposed S. 1134, saying, quote, "In our opinion, waiving the protections of the Wild and Scenic Rivers Act for the Lower St. Croix is bad policy, and it sets a dangerous precedent." Here in the House, this bill is also controversial. It's controversial because this bill is an earmark, pure and simple. This bill designates a specific project in a specific location, and it mandates the construction of a $700 million Exodus bridge design. And it does that all through an exemption to federal law. Of course, earmarks are banned in the House, except when a bill comes to the floor on suspension of rules, and all the rules and points of order are waived, just like this one. This mega bridge was highlighted in the New York Times editorial. The editorial highlights my Minnesota colleague and mega bridge champion, Representative Bachmann, who has called for a redefinition of what an earmark is to accommodate, quote, "a bridge over a vital waterway," end of quote. And today, Congresswoman Bachmann has been successful in bringing this earmark to the floor. Now, it's not just me. My dear friend from Minneapolis, Mr. Ellison, and other House colleagues in the U.S. Department of Interior are opposing this $700 million bridge. The bill is also opposed by Taxpayers for Common Sense, the Sierra Club, the National Parks Conservation Association, American Rivers, League of Conservation Voters, former Vice President Mondale, and a whole lot of Minnesotans who care deeply about fiscal responsibility, wise transportation investments, and responsible environmental conservation. Tomorrow, we will vote on this bill. The question is, will the House give a rubber stamp to a $700 million mega bridge, or will this Congress reject this bad bill and direct Minnesota and Wisconsin to come up with a smarter plan that would save taxpayers hundreds of millions of dollars? Every Minnesotan and every Wisconsin member of this House supports a replacement bridge, none more than me. But I ask my colleagues to reject this fiscal irresponsible bill. Not $1 of Minnesota transportation funds will be lost. I have a Minnesota Department of Transportation document in my hand that outlines how hundreds of millions of dollars could be reprogrammed across our state, creating thousands of jobs and rebuilding roads and bridges in great need of repair. S. 1134 is a bad bill, and it should be defeated by Democrats and Republicans alike. Mr. Speaker, I reserve the balance of my time.
Gentlelady reserves.
Mr. Speaker, I yield such time as I yield 2 minutes to our colleague from the state of Washington, the Chairman of the Natural Resources Committee, Representative Doc Hastings.
The gentleman from Washington is recognized for 2 minutes.
Thank you, Mr. Speaker, and I thank the gentleman for yielding. As Chairman of the House Natural Resources Committee, which has partial jurisdiction on this bill, I support Senate Bill 1134. For over 2 decades, Wisconsin and Minnesota have been working on a plan to replace this bridge, which is over 80 years old. This two-state project has been delayed by lawsuit after lawsuit and with interference of federal bureaucrats. These nuisance lawsuits and bureaucratic attacks are all based on the fact that the bridge spans the St. Croix River, which was listed in 1972 under the Federal Wild and Scenic River Act. This bipartisan bill simply says that the wild and scenic label on this river under federal law cannot stop these states from building a safe new bridge. It's as simple as that. And in regards to earmarks, which was brought up by the gentlelady from Minnesota, this bill has been reviewed and is in compliance with the earmark definition in Clause 9 of Rule 21. The bill does not contain congressional earmarks, limited tax benefits, or limited tariff benefits. The bill is aimed at ensuring the Federal and Wild and Scenic River Act doesn't prevent a safer bridge from being built. It affects multiple states. So, Mr. Speaker, the people of Minnesota and Wisconsin have been waiting decades to build this project. Let's pass this bill and allow them to do so, and I thank the gentleman for yielding. I yield back my time.
Gentleman yields back. Gentlelady from Minnesota.
Could I please inquire as to how much time I have remaining?
Gentlelady has 11.5 minutes remaining.
Thank you. With that, I would yield 3.5 minutes to Mr. Ray Hall of West Virginia.
The gentleman from West Virginia is recognized for 3.5 minutes.
I thank the gentlelady for yielding. Mr. Speaker, I didn't quite know from which side to request time on this issue. You see, I am for legitimate, well-scrutinized, scrubbed, and screened earmarks. Now, unless the GOP leadership can convince me that this is not an earmark, then I will vote no on the bill. We should be here today debating a long-term surface transportation bill, a robust bill that would create jobs and keep our economy moving forward by rebuilding America and putting Americans to work. Rather, we are considering a bill that authorizes construction of a specific bridge between Minnesota and Wisconsin with an estimated total project cost of $574 million to $666 million, an earmark. Instead of openly acknowledging that this bill is a blatant earmark, the Republican leadership pretends that it is not one, and quietly added it to the schedule less than 48 hours ago, and has scheduled it for this post-sundown debate. Now, do not get me wrong. I'm not against earmarks. But let's be open, transparent, and honest with the American people. That's why earmarks got the bad name it did, because we were not open and transparent and honest with the American people. So if there's any doubt whether the bill that the House is now considering is an earmark, all you have to do is read the bill. Read the bill. It says, may authorize and assist in the construction of a new extra-dose bridge crossing the St. Croix River approximately 6 miles north of the I-94 crossing, end quote. Then the bill goes on lines 21 through 23, page 2, section 3. It provides an offset. Guess where that offset comes from? Earmarks under the safety lieu, under previous transportation bill, is how the majority is using to fund this bill. That was our last transportation bill that took so much grief. It all sounds pretty specific to me. In fact, the bill even tells the states what kind of bridge to build. If it looks like a duck, swims like a duck, and quacks like a duck, by golly, it's probably a duck. This is an earmark. And I sincerely hope that some 90 new members on the majority side are learning just what an earmark is. Now, I recognize the need for this new bridge crossing St. Croix to replace the deficient 80-year-old Stillwater lift bridge, but I also recognize the need to move similar transportation projects across this great country, including my own home state of West Virginia. What we ought to be doing is passing a long-term, robust surface transportation bill so we can address the backlog of deficient bridges, roads, and transit systems in every state across the nation. Instead, we're voting on one earmark. and we are doing nothing today to strengthen our nation's economic competitiveness and quality of life. Nothing to alleviate the congestion that continues to cripple the economy in California. Nothing to fix the bridges that are in disrepair in my home state. Nothing to solve the fact that trains are traveling on outdated tracks across this country. Nothing to address the commerce that is being trapped on turnpikes because these arteries of commerce are being choked by a transportation system ill-fit for the country that is leading the global economy. Last November, Mr. Speaker, you announced that the House would take up the surface transportation bill by the end of the year. We all know what has subsequently transpired, that the Transportation and Infrastructure Committee produces a bill which slashes $15.8 billion in highway funding to the states, destroying 550,000 American family wage jobs. The bill then proceeded to the Rules Committee, where it was divided up into I don't know how many different pieces because there weren't votes to pass the whole package, and who knows what kind of mishmash we got that time. I'm still trying to figure it out, and who knows what type of mishmash we'll get the next time before we finally, if we are going to pass a transportation bill that puts Americans to work, gets our economy moving, and helps long-term deficit reduction.
The gentleman's time has expired.
Yes.
The gentleman's time has expired.
I'm not on my time now. I'm reclaiming my time. He has used it, and I'm not yielding on our time.
Gentlelady reserves. Gentleman from Wisconsin is
I
recognized.
yield the gentleman from Washington 30 seconds.
I thank the gentleman for you. With all due respect to my good friend and colleague from West Virginia, each person may have their own definition of an earmark, but we are governed by the definition of House rules, not the cavalier quacking of the duck standard. The bill has been reviewed and is compliance with the earmark definition in Clause 9 of House Rule 21. The bill does not contain congressional earmarks, and I know the gentleman has been very open about his support for earmarks. But we are governed by the rules of the House, and it does not. The quacking ducks comparison does not stand here, and I thank the gentleman for yielding and yield back.
Just read the bill, that's all I was doing.
Mr. Speaker, at this time, delighted with the bipartisan support for the measure before us, and yield 1 minute to my colleague from Wisconsin, Representative Baldwin.
Gentlelady from Wisconsin is recognized for 1 minute.
Thank you, Mr. Speaker. I rise today in strong support of the St. Croix River Crossing Project Authorization Act. This past November, I had the chance to visit the existing 81-year-old Stillwater Bridge, and I met with local community leaders on the issue. After seeing this bridge for myself and listening carefully to arguments on all sides, I am convinced that this legislation is necessary, reasonable, and time-sensitive. The bridge project will support thousands of construction jobs in both Wisconsin and Minnesota. In addition, the new bridge will help shorten travel times, reduce traffic congestion, and most important, improve safety. Perhaps it'll even save some lives. The stories I've heard from Wisconsinites who use this bridge every day are truly startling. I've heard from some folks who literally fear for their safety and are afraid something similar to the I-35 bridge collapse could happen to them. I've heard from others about the long delays and frequent spring closures of the bridge. This is the reality on the ground, and it is woefully unacceptable. We have the power to change this. I urge my colleagues to vote yes and support this bipartisan legislation. I yield back the remainder of my time.
The gentlelady's time has expired. Recognize the gentlelady from Minnesota.
I would like to yield a minute to Mr. Holt of New Jersey.
Gentleman from New Jersey is recognized for 1 minute.
Mr. Speaker, I thank the gentlelady. You heard from Representative McCollum the dimensions of this, how close it is to an existing large bridge, why this is really a boondoggle. I wanted to talk about how this fits in the national picture of wild and scenic rivers. This bill would, for the first time, waive the requirements of the Wild and Scenic Rivers Act, a law that has protected the lower St. Croix for nearly 30 years, protects 12,000 miles of rivers in 38 states and Puerto Rico, including the Delaware River in my home state of New Jersey. These are special rivers designated under the Wild and Scenic Rivers Law. When the Resources Committee marked up us now, I offered a simple amendment. My amendment would have ensured that any bridge authorized under this bill be designed and located in a way to minimize the direct and inverse environmental effect. It was defeated. This is really a bridge too far. It's far too large. It is just, far too expensive. And should Congress pass this bill and waive the wild and scenic river protection, it's hard to imagine any future bridge project that won't receive a waiver like this issued by Congress.
The gentleman's time has expired. The gentleman from Wisconsin is recognized.
Mr. Speaker, at this time I yield 2 minutes to our colleague from the state of Utah, Representative Rod Bishop.
The gentleman from Utah is recognized for 2 minutes.
Thank you, Mr. Speaker. In 1972, the Wild and Scenic River Act was used on this part of the river, even though there was already an existing bridge on that river. Now, the safety of that bridge is creating problems for people, and the traffic buildup is creating problems for people. And actually, the National Park Service already had met with everybody, found a way to build a new bridge, mitigate the adverse circumstances, and an agreement was reached until outside groups who came in here with this dogmatic reverence for the Wild and Scenic River Act basically took it to court, threw everything away, and we have now exacerbated the problem. Wild and Scenic River, on a clear day, if indeed the traffic does not produce enough smog that has backed up because trying to get across this river, you can actually see a marina, the smokestacks of a power plant that is in the neighborhood of a sewage treatment plant, and maybe even the orange jumpsuits of the county jail that is in this area. We are abusing the law to stop this progress that stops this bridge that is needed desperately for safety reasons and for traffic reasons in this particular area. There is a reason this bill passed by unanimous consent in the Senate. It solves a problem. It's common sense. It's the right thing to do. I yield back.
The gentleman yields back. The gentlelady from Minnesota is recognized.
Thank you. I don't think my constituents consider me an outside group. With that, I would yield 1 minute to Mr. Grijalva of Arizona.
Thank you very much, Mr. Speaker. I rise in opposition to the legislation. This bill is too controversial and should not be on the suspension calendar. Last year, the majority held a hearing on the issue in the Subcommittee on National Parks, Forests, and Public Lands. The Park Service testified against the bill. It was also opposed by a range of national organizations, from fiscal conservatives, tax watchdogs, organization, and environmental conservationists. This bill has already been stated would create the first ever exemption to the Wild and Scenic River Act for construction of a bridge in a protected river. This has never been done, and the question is, why now? This precedent for a $700 million mega bridge that threatens all 203 protected rivers in 38 states should not be allowed to proceed. And it very much violates the no earmark pledge of the Republican majority. Congresswoman McCollum and Congressman Ellison introduced a better bill, H.R. 3434, that removes congressional mandate found in this bill that is under consideration and sets a spending cap to protect taxpayers. I understand the need to create jobs. I understand the need to fix our falling infrastructure. There are over 2,000 bridges in Minnesota and Wisconsin that need immediate, dire attention. That would create jobs, and it would move the infrastructure needs of this country in a very, very direct way and in a very needed way. This is a waste of taxpayers' money and a violation of the Wild and Scenic Rivers Act, and I yield back.
The gentleman yields back. The gentleman from Wisconsin is recognized.
Mr. Speaker, this bill has bipartisan support, and other things being equal, I think we tend to listen to the representative in whose district a project would exist. This district is in the district of my colleague Ron Kine from the state of Minnesota, and at this time I would be happy to yield him 4 minutes.
How much?
Thank you, Mr. Speaker, and I thank the gentleman for yielding me this time. Mr. Speaker, this bridge is in my congressional district. I have been living and breathing this issue for the last 16 years. Mr. Speaker, it's time to build a bridge. This is a bipartisan bill. It passed the Senate under unanimous consent, and this legislation before us today merely exempts this river under the Wild and Scenic River Act, exempts this bridge so that the states of Wisconsin and Minnesota can move forward on this vital infrastructure project. This is what we have today, Mr. Speaker. It's an 82-year-old lift bridge that's on its last leg. Last summer, the drawbridge was up for 10 days, prohibiting traffic from crossing because of high water. Every summer, every time a boat travels underneath this bridge, the lift bridge is lifted, and we have a traffic jam miles long waiting for the bridge to open up again. Those cars and trucks are spewing fumes, dropping oil. It is a major environmental problem, not to mention the safety concern that we have with this old lift bridge. It's on its final leg, and there's consensus that we have to build a new bridge. This is what's recommended by the states of Wisconsin and Minnesota. This is what the new bridge would look like. And yes, you will see right next to it is a coal-burning power plant on this so-called part of the Wild and Scenic River. There's very little wild or scenic at this location, and that's exactly why it's being sited at this location, along with two major manufacturing plants. This is another view of the bridge in relationship to the power plant just south of the Stillwater area. And this is actually the view from downtown Stillwater looking south along the river at this bridge. You can barely see it because of how it's designed to blend into the atmosphere. And Mr. Speaker, about 6 years ago, I formed a process called Resolve to get all the stakeholders at the table so that they could discuss and scrub every option and every alternative that was available. At the end of that 5-year negotiating process, 26 of the 27 stakeholders reached an agreement on what needed to be done. The only holdout was the Sierra Club, and that's why we're having this big debate this evening. But even their proposal that came in at the 11th hour would cost just as much. It would take another 10 years to build, and it would actually cut into the bluff on the Minnesota side, causing more environmental damage. Even the local and regional offices of the National Park Service and the Fish and Wildlife Service had signed off on this bridge project. I believe, as do most of the members of the Wisconsin and Minnesota delegation, as well as all 4 of the U.S. Senators, that it's time to build this bridge. Both governors in Wisconsin and Minnesota want to build this bridge. The Department of Transportation in both Wisconsin and Minnesota want to build this bridge. 92% of the residents in Wisconsin want to see this bridge go forward. 88% of the residents in Minnesota, in Representative Bachman's district, where the bridge is also built, wants this bridge to go forward. It is time to build this bridge. And every option, every alternative has been considered. And this is where we keep coming back to time and time again. They looked at the cost, they looked at the design, they looked at the location, they looked at the environmental impact, they looked at the mitigation that can be done. And 26 of the 27 stakeholders reached this conclusion. And it's unfortunate that the Wild and Scenic River Act is being used to bludgeon a major infrastructure project that will create jobs in this region when we need them the most. Not only the short-term jobs in building this bridge, but the long-term economic development and the explosion of economic growth and job creation that will result from the creation of this bridge. Heading south, as my colleague from Minnesota had suggested, to hook up to the interstate highway was not a viable option. We have the town of Hudson that lies in between. Mr. Speaker, I ask unanimous consent for 2 additional minutes.
If we could have 2 additional minutes on our side, I have no objection.
The gentleman is recognized for 2 minutes.
Thank you, Mr. Speaker. Going south to hook up to the interstate bridge down there is not a viable option. That, too, is under study for an expansion given the increased traffic load that's going through it today. What this bridge that's being proposed considers is not only current traffic flow projections, but future traffic flow projections over the next 20 or 30 years. I know infrastructure projects can be difficult. I know they can be contentious. But when so many people at the federal, state, and local level, the agencies, as well as private entities, have been at the table for 5 years negotiating and trying to reach agreement on what bridge is necessary, when they do finally reach an agreement, that tells me it's time to build a bridge. Now, I want to thank the ranking member and the chair of the Transportation Committee for your support, as well as the chairs of the subcommittee and the ranking on the subcommittee for your support, Transportation Secretary LaHood, has been strongly in favor of moving this project forward. And I also want to thank the administrations, the governors of both Wisconsin and Minnesota for their interest and their support for this project. One of the reasons it's being brought up at this time is because Governor Dayton from Minnesota says that life is short and they need predictability and certainty on what projects are moving forward. He's been a strong advocate of this bridge, but we can't be delaying this and dragging this out for another 16 years, which is the likely outcome if the opposition figures out a way to bring this bill down. Enough is enough. We have explored this, we have exhausted it, and we keep coming back to the same place as before, this bridge, which makes this legislation necessary, and I encourage my colleagues to support it so we all can move on with our lives. I thank you, and I yield back my time.
The gentleman yields back. The chair wishes to clarify that each side now has an additional 2 minutes. The gentlelady from Minnesota is recognized.
Thank you. Could you please tell me how many minutes I have besides the 2?
The gentlelady from Minnesota has 6 minutes remaining.
6 minutes, and could I ask how much my friend from Wisconsin, Mr. Petri, has?
The gentleman from Wisconsin has 10.5 minutes.
Thank you. As I said in the beginning of this debate, this is a bad bill. Excuse me. I would like to yield myself 2 minutes, please.
The gentlelady is recognized.
As I said at the beginning of this bill, SR 34 is a bad bill, and it reflects our irresponsible fiscal policy, bad transportation policy, and bad environmental policy. The way the law has been structured into making this moment happen specified only one type of bridge could be built, and it had to be a bridge that went 65 miles an hour. And then the legislation before us today takes it even farther and for the first time puts in that a bridge that is going to be a replacement bridge in the Wild and Scenic River must be an extradose bridge. It mandates the size and the scope of the bridge. Ladies and gentlemen, we just could have had a piece of legislation that would have allowed an exemption without the specification that was added in this legislation. I could have stood here and supported it, but I cannot support a $700 million interstate bridge when there's one 6 miles away. The Stillwater Bridge needs to be replaced. But it won't be replaced, actually, because it's going to be, the historic lift bridge is going to be used as a bike and pedestrian bridge, which in perpetuity, the states of Wisconsin and Minnesota will have to maintain and repair, and will continue during the summer to be raised and lifted as boats go through.